Barrister Thompson's Office, Episode 1.
Please kindly explain to us whether it is right in law for an employer to terminate the appointment of an employee over an offensive conduct which has been condoned.
What is condonation? The word is generally used in criminal or matrimonial causes. The Apex Court gave a definition or description of the word in the case of PML Nig. LTFV. FRN 2017 LPELR 43480 SC as follows. Condonation is the voluntary overlooking or pardon of an offense. See Merriam-Webster.com, wherein condonation is also defined as implied pardon of an offense by treating the offender as if it had not been committed. The difference between the two, therefore, is that while the compounding of an offense does not mean that the offense had not been committed, by condoning the offense, the offender is treated as if the offense had not been committed in the first place. Condonation is, principally, used in canon law and military law. In canon law, condonation is a defense to an action for divorce that the innocent spouse having forgiven the adulterous spouse cannot now take proceedings. See legal_dictionary, the Free Dictionary, com. In Nigeria, Section 26 of the Matrimonial Causes Act provides that except where Section 16(1) of this Act applies, a decree of dissolution of marriage shall not be made if the petitioner has condoned or connived at the conduct constituting the facts on which the petition is based. In his book, Nigerian Family Law, Professor I. Tsugai expounded thus: in law, there is condonation when one spouse, with full knowledge of the matrimonial wrong committed by the other spouse, reinstates the offending spouse to his or her earlier marital position, with the intention that the spouse whose wrong is so condoned does not henceforth commit any further matrimonial offense.
Okay, sir, actually there are established precedent as you stated. How can we then infer to the employer and employee issue at hand?
In the revised editions of 1999 and 2004 of the Black's Law Dictionary, the authors brought to fore the definition of the word condonation as it relates to the general application of the word, where they defined it to mean victims express or, especially implied, forgiveness of an offense by treating the offender as if there has been no offense. Condonation has two essential ingredients. They are 1. Forgiveness of the wrong person, and 2. Reinstatement of the offending person to his former position. Where, for instance, an allegation of not making full disclosure of employment history was raised, and on that basis, the employer dismissed the employee but shortly after reinstated him until this second attempt at dismissing the employee. The facts therefore are not disputed, and the allegation of non-disclosure is not a new allegation. The question one might ask is, since it was overlooked previously, let me not use the word condoned yet, what makes the employer thinks it would keep raking up allegations that were treated and overlooked before as if in desperation to dismiss him?